Good morning, everyone, and welcome to Human Resources Basics with Kim Banks. Just a quick reminder, this is a webinar setup. If you are attending virtually, just go ahead and raise your hand or put your question in the chat, and we will go ahead and let Kim know. All right, the Cal Poly CIE SBDC, just a little bit about us. We are a national program with over 1,000 locations. Our purpose is to help stimulate economic growth through business development. We are partnered with the SBA and we serve San Luis Obispo County. And the way that we are able to provide our assistance is we provide no cost obligation, consulting and training to small businesses and entrepreneurs. And the way that we're able to provide that at no cost is thanks to our sponsors. We are funded by the SBA as well as the California Go Biz. And then I have a very brief sponsor video to play from one of our sponsors, Maynard Cooper Gale.
Hi, everyone. My name is Jamal Al-Haj, and I'm a partner with Maynard Cooper & Gale in the firm's San Francisco office. Maynard Cooper is a full-service law firm of national reach with over 300 lawyers across 11 offices coast to coast. Our San Francisco practice focuses on advising emerging growth companies and venture capital firms, including with respect to equity management, financings, employment, and intellectual property matters. We are extremely proud to be a Founders Circle sponsor amongst an extraordinary circle of other dedicated philanthropists who recognize the immense value that Cal Poly's Center for Innovation and Entrepreneurship bring to the SLO community. We hope that each of you enjoys this upcoming training and workshop and are able to incorporate the knowledge and know-how that will be presented shortly to further help grow, develop, and accelerate your businesses.
Thank you, Maynard Cooper Gale. And without further ado, I would like to introduce Kim Banks, HR consultant, and go ahead and take it away, Kim. You can go ahead and share your screen.
Hey, good morning. Yeah, deal with technology here very quickly. Great, good morning. This, I noticed that it was kind of touted as HR basics, and I really wanted to talk a little bit about how do you set up even before you start having employees. So my agenda today is to kind of go through some different options that you have as a business owner, how to set up. I'm sure this is not new news to any of you, but I just wanted to touch on it very quickly. Also talk about what do you need to have ready before you can run first payroll. And then we'll talk about the employee life cycle, and then talk about some solutions and options that might be available to you for you to consider as business owners. So first of all, let's talk about the different business types that that are available to you and what you might want to consider when you really think about it. So again, this is not my forte. I'm a human resources consultant. I've been in human resources for over 25 years. I've been in-house. I've worked for the majority of my career in hospitality, and then I went into the nonprofit sector, and now I'm a consultant for small businesses from Paso Robles to Lompoc. And the average size of my clients have about 30 employees, but I have some as low as just 1 or 2 employees and some as high as 100 employees. So it's a good range for me, but it's very interesting to have kind of understand the dynamics that business owners need to think about. And so these are just the quick different types of businesses, setups, business types you can have. And then what are the pros and cons for each of them? The sole proprietor puts you at the most risk as an individual owner because you are personally on the hook. You have liabilities. If something goes wrong with the entity, there's a lawsuit, all of that is going to be falling on yourself. Whereas other C Corp or S Corp, you have, and even an LLC has more protections for you. So again, I think it's just important for you to make that decision as you're looking at how your business is going to change over time. You may start as a sole proprietor and then at some point decide to go into a C Corp or an S Corp or even an LLC entity type. And I've assisted several of my clients who have done that, and there's just a lot of little steps. It's like a domino effect. You can't do step 2 until you get step 1, but step 1 has a prerequisite, and it can just be really confusing. So it's great to have some good advisors for you, aligned with you to kind of manage and walk through that process. But let's talk about, okay, so now you're thinking, I'm going from just kind of being an entrepreneur, getting this startup going to, yes, now I actually need to hire somebody, I need help, and I'm going to have an employee. So there's some things you need to have ready. You definitely want to have your FEIN set at the federal level. You also need to have your Secretary of State with California filed. And if you have an FBN, a fictitious business name, you need to have gone through that process. If your company includes your own name, you don't need to have an FBN, but if your company does not include your own name, you do need to get an FBN. And that's a step that I see a lot of my clients miss, to getting that FBN filed. The process is pretty simple. My husband and I have a side business. We had our FBN set up last year. There's just steps. It takes a little bit of time. You have to have it posted in the newspaper, those things. But once it's done, it's done. You also need to have a state tax ID. Now, there's a couple things. If you are in retail, there's a whole other tax, the state taxes. But what I'm referring to for payroll is the EDD, employer tax ID, that you need to set up. And the most important thing on all of these things is make sure everything matches. Where I have seen employers have difficulty or later have issues and going back and cleaning up is when the naming is off just a smidge between all the different entities. So you want to make sure your IRS, your FEIN, your Secretary of State, your California EDD account, that they all are consistent and they match in the naming. It's small change, really creates a snafu for you later, and it's a headache to get cleaned up. You also need to have a payroll banking account that's attached to your for running your payroll. Now, the other things you want to consider is I highly recommend that you have general liability insurance for your organization. And then if you're going to have employees, you must have workers' comp insurance. And so workers' compensation, protects the employee from being injured on the job. It is expensive. If in kind of white collar positions, it's less expensive, but you start getting into labor intensive positions and it can be very expensive. I like to consider for employer taxes, work comp, and other benefits that you might be providing and taxes you need to pay, I usually consider just a 30% up margin. So if I figure I'm paying this person, do quick math, HR is my forte, not math. If I'm paying somebody $15 an hour, 30% of 15, add that to the top. So to put that in your budgeting, because that's about what it is. It might be a little less, but I just 30% for the easy number. Pardon me. 2 other things you may want to consider having is D&O insurance. And D&O insurance is directors and officers insurance. And that's if you have a board. I'm so sorry. Pardon me. If you have a board of directors, that board may want to have D&O insurance, protect them from business decisions. And then another thing that you may not need immediately, but you might want to consider having down the road is what's called EPLI, Employer Practices Liability Insurance. And that is a protection from your management decisions regarding employees. So if an employee sues you, your EPLI insurance will kick in with a deductible. Do you want me to stop and while I get that sorted?
Yeah, would you mind just for 1 second?
Sure, we're going to take a quick pause for those of you who are online. We're having a little bit of a spasm on our video.
Yes.
Right. As workers require that all your employees are all virtual too.
Yes.
Yeah.
Because you're still on the hook for their repetitive motion injuries, their ergonomics aren't set up at their home. they have their setup like this and they trip and fall in their own home, but it's based on the equipment that they're used to doing your work, you can have a work comp. Yeah. Now, the other thing to think about, if you have remote employees and they're in other states, these things I talked about need to be set up in those states. Because you have, if you're paying them in that state. And so there's employee taxes and employer taxes for that state. And so you need to have these accounts set up, a state ID, a state tax account, so that you can pay and make sure that your workers' comp coverage extends to all the states where you have employees remotely living in. So on one side, the remote employee really is a great feature, but on the other side, you want to make sure that your payroll company and that you're all set on what's going to be required as an employer in those states. And the employer laws that come into play are the employers of the region, are the employment laws of where they live or where they're working, not where your business is set up. So it's just things to keep in mind. If there's a different minimum wage, if there's requirements for vacation and sick and all of those things, you need to know what's happening in that state. And it can get a little bit convoluted with remote workers and multiple states, especially for a small employer. Larger employers kind of have that, usually national employees, and so it's very easy for them, but for a small employer, it's just another hurdle to manage. Can be done, but it's definitely something that needs to be managed.
Are there any subscriber-based programs to deal with those complexities?
Yeah, we can talk about some solutions at the end. Absolutely. Okay.
Restarting the purchase.
Great.
Rebooted it.
So it's exploring that.
Oh, yeah, I was rebooted it. We got here though. It happens. Thank you.
Sorry about that.
So the employer practice liability will keep you from a discrimination lawsuit, a sexual harassment lawsuit, any kind of management practice lawsuit. 99% of EPLI policies will not protect you from wage and hour. Wage and hour lawsuits go a different route, and there's only, I've seen one or two where it's incorporated for protection, but most of those insurance policies will not. So that's your biggest risk as an employer, are wage and hour lawsuits.
Could you elaborate? What do you mean?
Pardon me?
Wage and hours?
Well, we'll get there.
Oh, okay.
Yeah. Okay. So you have an employee. Let's talk about all the steps and all the things that I recommend that you think about. We're going to go through this life cycle of kind of what happens to an employee from selection, all the things that happen throughout their time with you as an employee, and then when they leave you and they move on. So let's first talk about selection and recruitment. So first of all, you're going to want to have a job description, which I'll show you on the next slide is some samples. But we definitely want to review a job description. You want to have one if you're going to be advertising for a job. You want to think about how do you want to advertise? Are you going to place an ad, or are you going to be using your word of mouth and try to get just the information out there? Social media, there's a lot of avenues you can take. Social media is very affordable. You know, an ad on Indeed is going to be much more expensive for a small employer who has, it's just hiring their first employee. And Indeed can be difficult to manage because you're hitting such a wide net that you're going to get a lot of resumes that are not even applicable or available to you. So it can sometimes be a little bit daunting. Indeed's got another great way to source employees. And let's talk about what you need to do to respond and retain applicants. So the one thing I want to make sure that as a new employer, you want to have a job description. And so your job description is your legal document that says this is what this job is going to be doing. And it's going to cover, what is the purpose of the position, but also what are the essential functions and the qualifications, and then the physical requirements. And this piece, that physical requirements piece, can come in to really help you later for a claim from the American Disabilities Act, somebody saying that they need an accommodation. You need to have kind of those physical requirements really played out into what the job is. Also your qualifications. And the thing is once you write this and then you start recruiting, it's really easy as an employer. You recruit, you meet somebody, you just connect and you think, oh, this is the great person, I want to go with them, but they may not meet these requirements and you may be creating an issue for yourself. If you reject somebody who does have the qualifications and you hire somebody who does not, based on just that personal connection, and yet one falls into a protected category, one is of a certain race, one has a different, anything that could later look discriminatory in your hiring practices. So once you write this, you kind of need to stick to it. I mean, it is your roadmap. When you're placing your advertisement, there's two things. So if you've ever been, I've worked with folks, hi, good morning, who have come in from outside the United States and they're placing ads and they say things that you just can't say in California, you know, like I'm looking for a female, or I'm looking for somebody with this weight and height requirements, or must be able to fit into this uniform. You cannot do that here. Other countries that's still allowed, not here. You don't want pictures. Please don't ask for a resume with a picture. That's pretty typical in Europe with CVs. They come with their picture. You want to almost like, I didn't see it, I didn't see it, I didn't see it. Just, you don't want to know that. You just want to look at the qualifications. And really, this is to protect you from a discrimination hiring claim. So make sure your advertisement is based on the job description. Be sure you clarify what are the hours of work. I could go on and on about whether or not you advertise the rate of pay. I do like the fact that some employers do put a range, but I can go on and on about strategy. If you're hiring at a higher pay level, if it's an hourly job, like you just need a laborer, clerk, or somebody like that, it's like it's minimum wage, then just say it's minimum wage, because you don't want someone who's looking for 75 grand a year when you're only looking at $15 an hour. So if it's really a $15 an hour job, then say it's a $15 an hour job. And that will help keep you from getting a lot of applicants and just really be clear about that. My other strategy is if you have a management position and you're like, hey, my budget can withstand up to 80 grand for this position, I never advertise my top tier. I always advertise a little bit lower, because everybody who applies is going to think, if you say the pay range is between 50 and 75, I guarantee you everybody who responds is going to say I'm worth the 75, right? Nobody comes in and says, oh yeah, I'm at the 55 level, right? No, they don't. So you put in this range, but what you're basically saying is they're all going to respond at the top range, and that's what they're going to expect. If your budget is 80 grand, when they come in at 75, and maybe they're like, oh, I could use a little more. Now you've created a little wiggle room to do some great negotiations and feel like a win, versus somebody who comes in and you post at the 80, but they're really not worth it, and you want to go in at 75, and now it's a first negative in that negotiation. So I always like to keep a little bit of my budget in the background when I'm advertising positions.
Kim, quick question.
Yeah.
Nowadays, it's so competitive, right? It's an employees market, people looking for jobs.
Yes.
Do you think it's helpful to actually post the salary nowadays, just to make it a little more compelling, to provide more information, to make sure you get better applicants? I mean, there's trends, right?
Yes, and applicants that are within the range. If I'm looking for something and I need 150 grand a year because that's where I'm at, and I see your job and you're really at the 75 level, and it's not posted, then I'm going to apply, and then you're going to be like, well, this is, and now I've wasted your time, I've wasted my time. Time is just too precious. I'm like, yeah, really clarify what you're looking for so the applicants know.
Yeah. And
I even say things like firm, like when I post a range and then somebody comes in making double that, and they're really trying to convince me, it's like, come on, my budget's my budget. Like I would love to hire you, but
I feel like it's such a seekers market that if there's not a range, seekers would be like, okay, I don't know, sorry, never mind, I'm gonna apply that, I'm gonna go on to the next opportunity.
Exactly. Yeah. Also, you know, if you have benefits, mention it. But the thing about an ad, so we talked about the job description. What I see a lot of employers do is they take an ad and they take their job description and they plunk it in the ad. That's boring. A job description is very legalistic. It should be written legalistic. It's going to protect you in a lawsuit, right? But your ad should be your marketing. It should talk about your culture. It should tell the story. You know, it should be alluring somebody to want to click apply, right? So your language in your ad should be much more engaging than your job description. Now, in your ad, you can say, here are the qualifications, and then you pull that over. But kind of your opening statement in an ad really should tell a story and be engaging and not just, here's the job description. Okay, sorry about that. I clicked something and then so now my screen doesn't want to. Come on. There we go. You want to respond to all applicants. So there's, I'm not very familiar with Glassdoor. Anybody heard of Glassdoor? Okay, so Glassdoor is Yelp for applicants and employees, right? So it's an anonymous survey. I can go in there and I can trash my employer or this applicant process, and it's out there for everybody. So you definitely, you're creating your image, you're creating your footprint in the community, and so you want to treat people well in the application process. You can just ask for resumes, but if somebody is going to formally apply for the position, you need to have an application. The state requires, an attorney is going to ask for it if something goes wrong. You want to have an application as well. So you can just source resumes, but once you're at that point of a second or a third interview, definitely have an application on hand. You want to keep records of your candidates who have applied for the job for 3 years. And you may be federally required based on some federal funding that you may be having to track the EEO status of your candidates, which is their employment, the equal employment opportunities. So their race, gender, those kinds of things, military status. And so you might be required to do that. There are applicant tracking systems as you get larger as an employer that I would highly recommend because it does all this record keeping for you and you don't need to worry about it. So let's talk about, okay, so you hire somebody and you think, oh my goodness, that probably wasn't a great hire. I love the adage, you know, slow to hire, quick to fire, especially in the first 90 days, right? So really take your time. When I teach hiring managers about hiring, you know, like interview questions and just as a sidebar, almost every one of my slides, I have a separate class that's almost several hours long just to get down into the granular. I always ask them, like, how long do you take to decide to purchase a car? You know, a car is 30 grand. You know, a minimum wage employee is about 30 grand. People will take days to make that decision to purchase the car, but to hire a 15-hour employee, they like 15 minutes to make the decision. And I'm like, no, think about it. You know, take a little bit more ownership of what you're spending on that employee. So, you know, usually they're saying the U.S. Department of Labor is saying about 30% of their first year potential earnings are what it's going to cost you to hire somebody. You have to just know that over half of resumes have inaccurate information, missing information, a gap, something that's in their story that they're not telling you. And in a small business, a bad hire can cost you. Studies are showing like up to $190,000 a year. So take the time, hire right, and make sure that that's really where you want to go. Don't speed hire. My recommendation. Okay, now we're in interviewing. Just remember in this state that there's definite things that are off limits, right? You don't want to ask any of these questions about their race or age or religion, right? You always want to keep all of your questions about the job. I've been to management training classes where they have some really cool questions about, tell me if, what would do better in a fight in the woods? Would it be, a bear or a lion? And I was like, what does that have to do with the job? Let's keep it to the job. Have really good questions ready. I'm a huge believer in behavioral-based interviewing. That's a whole other Oprah we could get into. But there, you definitely want to have strong questions. Yeah.
So I do have a question. We used to have someone from early employee at Amazon, super early employee, and he would always share this story that one of the questions that people were asked during the interview was, how many windows are there in Seattle? And truly, the question is more about how no one knows the exact answer, but it's more about how you think about it to understand your thought process. So if you're able to say, okay, there's X number of buildings per block, per floor, whatever it is, but it shows that you can actually think it through and figure something out.
Right.
So is that a legitimate question, or is that still borderline?
To me, I think it is. If it's what's important to your company and your culture, right? If that's what you're really trying to source through is their thought process and how they would attack a complex question, then absolutely. But if it's just kind of like, oh, are you a rainbow or are you a dolphin? Like what? And I've had those kinds of questions, and it's just like, that has nothing to do with my job. Yeah. But those where it's really about your thought process, I totally agree. I love kind of bringing in those kinds of questions that really are showing you, because an interview, what you're trying to get is trying to get some sort of predictability about how this person is going to perform in the role. And you want to make sure you're doing 20% of the talking, they're doing 80% of the talking, and you're really trying to discover how they work. That there's some creative questions.
And so as a follow-on to that, are personality tests appropriate? In the hospitality industry at the executive level, I know those are really common, which I find quite surprising, but is that a legitimate?
They are if they're backed, right? So since I started in hospitality, and I was a certified interviewer through Talent Plus, and Talent Plus kind of was it was an amazing interview process that we did. And I executed the Talent Plus interviews for about 7 years of my career. And I agree with them, but they're based on technology. I mean, they're based on data. They're like, here's how the best performers in hospitality respond to these questions. And so we're looking for those answers that match what the best performers would answer, not what I would answer, not what I want to hear, but their data show top 10 performers answer these specific questions with this nuance. So listen for that nuance, and they're more than likely going to be aligned with a top performer in hospitality. And that I agree with, absolutely. Yeah.
So Judy, I was made to take like a business personality test one time when I was interviewing for an executive position. Yeah. And it was very much like that ENTJ, but more styled towards business.
Yeah. And I don't think those are great after someone's hired, some of the ENTJ or the DISC or some of those things, because you're really talking about how do you work together as a team, like, and not so much about their qualifications. So I think there's a place where I would just be careful that there's backing in the study as to why you're using it, and data. Okay, so you've selected, you recruited, now you've got somebody who's about to start. So let's talk about your new hire process. There are certain things you can do in the pre-employment realm. You can do a background check if that's important to you. There's lots of sites that offer them to you. They can cost you as an individual employer. There can be anywhere from a pay range of, I think, $50 to $75 a check. As you get larger, it's cheaper based on volume. I recommend a criminal background check. I think it's worth it. The key is that you can only conduct and request that you do the background check after offer, before hire. So there's some nuance there in California about how you do it. There's a lot of disclosure that you need to provide the applicant. And if something comes up on their felony record that would preclude you from or make you want to rescind the offer, there's some steps you have to do that are very legalistic. There's definite steps you have to follow in order to do that carefully. So they're worth it. You just need to know that you need some help in kind of guiding through it. You can do pre-employment drug tests. In California, you can only drug test employees in a very limited cases. 1, pre-employment. 2, reasonable suspicion. And there's a whole checklist of things you need to look at. 3, potentially after a workplace accident, if drugs or alcohol could have created the accident. And 4, in DOT specific positions, such as, drivers of big trucks, anything that's DOT. Otherwise, you cannot just randomly drug test employees in California. So the only time you can do it is pre-employment. I recommend it. I use a saliva-based one. It takes 5 minutes. It's super non-invasive. I would recommend it. And then references. You definitely want to check references. The things to remember with references is the liability in references is the person who's responding to your reference and what they tell you. There's no liability in what you ask, right? So if you ask questions and they respond, if something is amiss in the hiring decision, the person gets upset about what you asked, it's that the person gave the information, not that you asked the question. So you can be creative in your questions. And then you have all the paperwork. Right now, it's almost like buying a house. Our new hire paperwork that I pass out is like a thick stack. So there's lots of things you need to have. You need to have that, like I mentioned before, that application, a formal application. If you're paying commissions, you want to have a written commission agreement laid out in advance when you're hiring them. You have the W-4 form. Did I include it? I didn't even include it. You also have the EDD, the DD4, which is the California state tax form. The I-9. The I-9 is the federal form that says I am legally able to work in the United States. You want to have all the information about your work comp carrier. You have to provide that at the time of hire. You have to provide insurance about disability insurance, forms or pamphlets about disability insurance, family leave, COBRA coverage rights if you offer medical. You have the state requires for you to file new employees with them, so that's the DD-34. Health insurance marketplace information. You have a wage and employment notice. You have to have a sexual harassment policy that they sign off on, and harassment, discrimination, retaliation prevention policy. So you've got a whole bunch of forms that you need, plus whatever is proprietary to you that you'd like to have, your policies and how you do things and your confidentialities and those things that you want to have as to protect yourselves.
Quick question.
Yeah.
Are the forms, the last 2, for example, the sexual harassment, what was it? Form and then harassment policy. Are those state provided or federally provided forms, or do you have to create your own?
So the form is state provided. It's a pamphlet that you get. The policy there's templates out there, but
You do have to create your own.
Okay, so what's an I-9? The I-9 is the federally required form that says I am legal to work in the United States. The employee fills out the first half. You as the employer have to fill out the back half. Here's the problem. Lots of new employers I work with don't realize that they need to fill out that back half. And what you're doing is you're looking for their documents that prove their right to work in the United States. So typically that would be a passport or a driver's license and their social security card, but there's a long list of items. And so if you are at that point of hiring and you've never filled out an I-9 form, you want to look into it and get instructions. There are fines that you can have an I-9 audit. You can come in, pull all your I-9s, and for every little administrative error, it used to be, it's been a while since I've been through one of these, but about 10, 15 years ago, it used to be $100 per error. So if you've got, 5 or 6 errors on one form, you've got 10 employees, that can quickly add up. And then if it looks like you're negligent, then they give the penalties on top of that. Not even, the person could be a legal citizen and be able to work in the United States, but because you didn't do the form right, you could have penalties. Okay, you want to keep a personnel file of all your folks, right? And so you want to have certain things in your personnel file and certain things that are outside of the personnel file. The reason for that is the personnel file is what gets shared. It might get shared with the employee, it might get shared with a manager or a supervisor. And what the other confidential information should not be shared with other folks in your company. So you can have in their personnel file, their application, their offer, all this paperwork, any kind of performance notes or letters of recommendation, letters from, just accolades and things like that, training documentation, forms that you have them sign for their rates, pay, and any changes that you do. But what you don't want to have in their file, which needs to be separate, are all the I-9 forms. They need to be in a separate binder. If somebody gets injured at work, that's a work comp file. You don't want that as part of their personnel file. When they sign up for benefits, that should be separate. Then you have a benefit file for that. Any kind of medical documentation where they come in and they say, hey, I need time off or I need an accommodation because I have this chronic illness, that is private information. It cannot be in their personnel file. That needs to be in a private benefit file. If you receive letters from some agency, there's a garnishment in place or a tax issue. All that is private information. That is not something that you share with other people in the agency or your company, that person has a child support or garnishment. That's private information. It's protected. It doesn't go in the personnel file. And then also any kind of employment verifications. Usually that's for they're buying a house or they're buying a car. And the reason why the state is very particular about kind of keeping these things separate is what you want to show is when a manager comes to make a decision. Let's say I'm making a decision to promote 2 employees that are internal, right? They really should be looking at the performance of that employee. They review the employee's file, the decision should be made on that and not based on the fact like, oh, look, this person missed a whole bunch of time last year for leave because of a medical condition, or this person just bought a house, or this person has 7 baby mamas and all these child support issues, right? So you don't want that information in your decision-making head, only their performance. And so that's why you have to keep all this information separate. Okay, so here's how I set it up. When I set it up, I've got the personnel file, I've got that confidential file, I've got my work comp file, and then I've got your I-9. Now, it used to be back in the day that if you got subpoenaed for employee records, the attorneys used to say, look, best practice is that these all need to be under lock and key, right? And they cannot be in the same drawer, because if you get subpoenaed for records, they can limit the subpoena to just your employee files, which are over here, and my work comps are way over here, so the subpoena doesn't cover that. Now subpoenas have gotten much more, they're more in depth, and they include all those other files that wouldn't necessarily be in the employee file. But it's still a recommendation that you keep it separate. So when you're setting up an office, you're setting up your record keeping, you want to have this. Now, a lot of folks are going digital, right? So you want to make sure that wherever you're storing those digital files are secure. Who has access? There really should only be 1 person in your company, or maybe 2, that have access to the private confidential medical information. And they can't be people that have decision-making over whether somebody's laid off or any of those employment decisions. So it's typically your HR person has that, or a risk person. Okay. You also have to have posters. So you want to make sure that you have the current poster in place. There's a federal poster, there's a California poster. Every occupation in California has a specific wage order. You have to have the wage order posted. You can either buy a laminated one, or you can go onto the DIR and just pull it down, but there's, I think, 16 different wage orders, and it tells you how you need to pay people that work under that wage order. So you have to have that posted as well. There's also a workers' comp MPN poster. That's the medical provider network poster. You also have to have that too. If you are remote and virtual, you need to have access to those posters, and the employees know where to get it. So you can store them somewhere on a shared drive and make sure your employees have the links of how to reach them. Okay, do we need to stop real quick? I know I'm just like barreling through, so I know I've got a lot to go through. Do we have any questions or anything?
Surprisingly, no, nothing in the chat just yet.
Okay, good. Like I said, I'm just giving a real, trying to touch all the pieces, but really quick. Okay, so what things do we need to think about? Now you're trying to pay people. So You know, is somebody truly an employee or are they an independent contractor? And that decision is getting easier and easier these days because the government is saying that they're all employees. They assume they're all employees. You really have to prove that they're an independent contractor. You have timekeeping requirements. You need to think about your work week and how you calculate overtime. There's piecework. There's a whole bunch of pieces. The reason this is so important that you want to worry about it is because this is just fiscal year 2019, 2020. I just pulled these numbers this week. So this is from the California Labor Commissioner's Bureau of Field Enforcement. So the people that respond to the wage and hour claims, right? They say, I didn't get paid minimum wage. I didn't get paid timely. I didn't get paid my overtime correctly. There were, oh, you know, the dollar sign, that shouldn't be there. There was 2,339 actual violations. Penalties were $142 million. Average cost per violation is in the 60 grand.
If I have a question, if you have someone like a bookkeeper and they have a bookkeeping service, how do you protect yourself as far as keeping them an independent contractor? Because when I owned a business, I actually ran into that and ended up losing, even though that person had their own bookkeeping service.
Really? We'll get into that, but the things that they need to prove to be an independent contractor. So these are the top 6 violations that happen in California during that time frame and how much the average claim costs. It's worrisome. And like I said, there's no insurance. Well, there's a very small percentage of policies under EPLI that will include wage and hour claims. So this you're on the hook for. So if you're a sole proprietor and you make a mistake, you're going to be personally liable. They can come after your house. I mean, this could be critical, cataclysmic for a small employer if they don't get it right on the wage and hour. You want to make sure that you have a handbook. Now, here's the thing. So I'm a little bit different than most HR people. Most HR people say, get the handbook out there ready, be ready. The thing about a handbook is whatever you put in the handbook, you better follow, right? So in some cases, as a small employer, it might be better to have some standalone policies and not a full handbook until you're ready to really have that handbook. Because if you get sued, the first thing an attorney is going to ask is, I want to see the employee handbook. Now, if you say, well, I don't have one, but here's my worksite policies that I have, that's going to suffice. But if you have a handbook and it says you do certain things and you offer certain things, and these are the rules that people need to follow, and you're not consistent in applying those, it's actually can work against you. So if you have a handbook, know it, follow it, and make sure that you're consistent. And anybody else that works for you, any of your managers, are also consistent in the handbook. You want to have something at the end that says that they received the handbook versus read the handbook. Okay, if it says I have read the handbook, then you basically need to pay them to sit down and read the handbook, right? So you may not know how to do it. You want to hand it to them and say, have them sign up that they received the handbook, and they realize that they're responsible for knowing what's in the handbook, but they are not required to read the handbook on company time. Okay. So here's where things have gotten really messy, especially the last 2 years. So there was pre-2020, there was this test called the Borrello test that basically was about the amount of control an employer has on the independent contractor and whether or not they truly are an independent contractor or are they an employee. And in 2020, that came into, they changed that into this ABC test. And then since then, there's even been more iterations of this law that happened in 2020 that was the Assembly Bill 5, right? So basically it's saying, like, you need to presume that everybody is clearly an employee first, right? And it's not about agreement. It's not about whether someone says to you, look, I just want to be an independent contractor. That doesn't matter. Like, what's going to fall is what the law says. And it's a burden is on you to determine whether or not they truly meet the requirements of an independent contractor. There's a really narrow definition of what is an independent contractor, right? So there could be this business to business exemption, and that's available to entities, but not to individuals. There's a 12-factor test. And you really, what basically is that the independent contractor needs to be providing services to the business and not to the customers of the business, right? So this is the ABC test. So first, the worker has to be free from control and direction in performance of the work. And here's the key, performs work that is outside the usual course of the hiring entity's business, okay? So I'm a plumbing company and I hire somebody who has, had his own plumbing company and he wants to work for me, but he wants to be an independent contractor. That's not gonna work in California. There was a time you might have been able to get away with it, but now you cannot do that. If what that person is doing is core piece of your business, then you cannot hire them as an independent contractor. But I'm a restaurant owner and I need to bring in somebody to fix my plumbing. That is not part of my core business. I am in food and beverage. I can hire an independent contractor to come in and fix my plumbing, okay? Now, the third part is that whoever you hire is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. Mainly, do they have a shingle in a way? Do they have a business? Are they doing work for many people? Are they out there advertising? Is that their business that they are doing and you're just one of their customers? So that's the key. And so if that's not the case, then they might be an employee. If they're only working for you and they're doing this side job, they might be an employee. So I think that's what some of the nuances are with the bookkeeper. Even if they say they do have or they can take other clients, if they aren't and they're not advertising that they do, then that could be a problem. And I'm just touching the surface. There's a lot more to this law. There's a lot of exceptions that have come up. The gig industry, the trucking industry, the entertainment industry, professional, insurance adjusters, human resources professionals. There's a huge list of exceptions. And I'm not going to get into that today, but if you are thinking independent contractor, really dig in and do the tests and make sure that they really qualify.
But if it's an LLC or an S corp, then the independent contractor status is more assured, right? Like if you're an LLC doing business with an LLC,
Yes,
then you're fine.
pretty much, yes.
Okay.
We did have one question come up in the chat. It is from Ingrid. She said, I have a question from the earlier section. We have an SBA loan. Is it the case that we would be required to track EEO status of employees? And when and how to gather this information in application or after hiring?
It's usually if there's a federal contract and not SBA loans. So usually.
Yeah, excellent. Thank you.
Okay, so let's talk about timekeeping. So this is where we get into this wage and hour claims. The violations for having a wage order violation could be $50 for every underpaid employee for each pay period, and then $100 for each for while you're trying to recover the wages. So these things grow immensely, very quickly. And there's now, I'm not prepared to speak about it today, but there's PAGA claims, which is the Private Attorney General Act, which is allowing employees and attorneys to go in and file a PAGA claim, and those are monumental. My daughter is a human resources director for a in-home healthcare company up in Northern California, and she said one of their franchises just got hit with a $7 million PAGA claim. Yeah. It's just ridiculous. So you really want to pay attention to wage and hour. Here's the thing. So many companies that I've worked with have a CPA and they use their CPA or their bookkeeper to kind of guide them, or their payroll company. Oh, well, I use ADP. So when I submit my time, wouldn't they tell me? No. ADP paychecks those companies, they just process your payroll. They're not going to look at what you're doing. CPAs, to become a CPA, wage and hour isn't even part of the test. My son-in-law is a CPA, and we get into this all the time. I'm like, there's so many small employers that kind of lean on their CPA, and they think they're the know-it-all, and they are in many, many things, but when it comes to wage and hour, they may not be the most attuned to California wage and hour laws. So I would warn you against just relying on a CPA's assessment on your wage and hour. Love CPAs. I just know it's just not in their wheelhouse, typically. So you want to make sure that you have people who are hourly, that you prohibit off the clock work. That those employees know, like you clock in, you work, but you're not supposed to be working outside of your on the clock. And if you're a remote employee, that you're really clear with them, how does that work? If I'm an hourly employee and I'm working from home, are there hours that they need to work? How are they managing their time to ensure that they're really working while they're on the clock? Be careful about rounding rules. Rounding is becoming a big litigious issue. Used to be, hey, you can round in California as long as it's fair to the employee and the employer, right? But it's getting more and more litigious. So if you have a time card where everybody writes in 8 a.m., lunch at noon, back at 1, out at 5 every day, you're probably going to be open for a lawsuit, because that's just not how life happens. You want to have people actually record their actual time in, their actual time out, and that you don't round those times. Overtime in California is not negotiable. It's not something you can have say to an employee, hey, you know, I don't care about overtime, I'll just do this work for you. It's very tempting as an employer because overtime is expensive, but it can come back to haunt you. I've seen cases where the employer agrees, and then later there's a falling out, and now that employer gets a wage and hour claim for all that unpaid overtime. Travel time. So if your employees are traveling, they're driving for work, there's a lot at stake there. You've got to pay them for that travel time, and you need to pay them for their mileage. So we've got a little, we have a little bit of a spasm again.
Yeah.
Yeah. So remote workers, okay, this is a huge issue with remote workers right now. So let's say you have a remote worker, but they're required to come in, they work from home 4 days a week, but once a week you have a staff meeting in the office. That commute now to the office is now considered travel time, so it's compensable because their home base is their home. So anywhere where they're driving from their home to anywhere is now going to be considered paid compensable time. Whereas before, I come into the office every day. When I leave my house and I go to my office, that's not compensable time because my home base is the office. But now that I'm working from home, that's all shifted. Okay, if you say, yes, once a month we have a meeting and everybody from all over the country needs to fly in or drive in to this meeting, that's all compensable time. You want to make sure you have an official work week and then you have an official work day. And this is how you calculate overtime. So you have over 8 or over 40 in a week, and on the 7th day of work is overtime in California. You can set up an alternative work week, and that's where folks vote. You set up a plan, you say we're going to do 4 10s, or there's a lot of varieties of alternative work weeks that alternate, 2 days off, 3 days off, very creative ways, but there's a process that you need to follow to implement an alternative work week, and it needs to be voted on, it needs to be filed with the state, it needs to be certified, so that you don't later come on the hook for unpaid overtime. The other thing you want to be careful about is overtime is time and a half, right? So for easy math, if I made $10 an hour, my overtime rate would be 15, right? But in California, overtime is calculated on what's called your regular rate of pay. And so what you look at is your total earnings for that week. So yeah, I make $10 an hour, but I also make $500 in commissions. So that influx of commissional rate needs to be calculated into my overtime rate. So if you pay gratuities, commissions, any other earnings, or I have 2 jobs and I make this much when I'm doing this job and that much when I make that job, then my overtime rate needs to be a calculation of all that. Some people call it a weighted average, but you basically take all earnings, divide it, and then create your overtime.
How do you do that if they don't even offer up that they have a second job?
No, not their second job, for you.
Oh,
They
just
work
both.
for you. Yeah.
Okay.
If you have commission-based pay or piece rate, a lot of employers like that piece rate pay. There were rules that came out in the last 2 years that say, look, if I'm worked on commission or on piece rate, there's an underlying incentive for me to not take my breaks and to not take my meal and rest breaks, because if I do so, I'm making less money. And so the state is now forcing employers who pay people that way to calculate an average of what they would have made and then include that and augment their rest break time with that amount, that kind of uptick in wages. So it's another calculation that you need to do, and it can be tricky. So again, it's something to think about. I have employers a lot of time who just come in and say, hey, I just want to pay everybody by the piece. I'm like, you can, but let's look at the minefield you're about to walk through, and let's make sure you're protected and we know what we're doing. Also, exempt versus non-exempt. I had a conversation with somebody just the other day that said, hey, I'm making everybody in my office exempt. Like, not necessarily a wise move. So exempt means I'm salary, I'm exempt from overtime. You pay me a flat wage regardless of how many hours I work. And then non-exempt is hourly. I get my meal and rest breaks, I get my overtime, I clock in, I clock out. And so to be considered exempt in the state, there's a variety of classifications that person needs to meet. It's mainly about, are you supervising other people, or how much discretion in the job are they using? If more than 50% of their time, they're using their own discretion or their own knowledge in the work that they're doing, then they may qualify to be exempt. And there's a text there, the state puts out these little charts that you can do the math and really decide, does this person qualify to be exempt? But just because my title is manager doesn't necessarily mean that I'm exempt. If as a manager, I'm spending more of my time working as an hourly employee, then the state is going to say, no, you're misclassified, you're an hourly employee. A great example of this was years ago, it happened in the food and beverage industry, in the restaurants. They would have a restaurant manager and they'd pay them exempt. And then they'd send all the staff home, and the restaurant manager is seating people and walking around and filling up waters and clearing, and helping out the kitchen and working the floor. And if they were doing that more than 50% of their time, they're hourly, they're not salaried. And they had many lawsuits in that industry of people suing, saying, look, I'm misclassified and I get all that overtime. They go back 3 years to calculate missed and unpaid overtime, meal breaks, all of those things.
What if there's a seasonality to the business where a manager like that, would have enough employees to be considered supervisory, and then during a slow period of the year, they become more hourly? Would you actually have to shift their position?
To be safe, I would, or look at what they're doing. It might even be just cheaper to have them continue doing what they're doing and keep one employee on to do that work.
We have a couple more questions in the
Yeah.
chat from Ingrid. She said, question regarding travel time for our business where the base is a restaurant in Paso Robles. When employees staff catering events at different locations and distances to and from home, and location is greater or less than distance to and from restaurant, how is time and mileage calculated?
Oh, that's a great question. I just had a great conversation this week about this. So typically the law says that the commute time from their home to wherever the job site is not compensable. So you wouldn't have to pay for that time. If the employee knows when they take the job that means that the jobs could be in a variety of places, there is an argument that you wouldn't have to pay for it regardless of how far it is, as long as they've agreed to it. I am a little bit more conservative. I would say, hey, if their normal commute time is 15 minutes and now they're driving 45 minutes, I would probably just go ahead and pay that extra 30 minutes time to be safe. But I had a payroll specialist really argue with me and pull up the law and say, you don't have to, as long as they do no work from leaving their house to getting to the site. Now, where employers get in trouble is the employee leaves their house, swings by somewhere, the restaurant, the yard, a shop, picks up supplies, and then heads to the site. The minute they've arrived there at the shop or the yard or the restaurant, now it's compensable time moving forward.
And she had one more question regarding required paid 10-minute breaks. How can these be documented?
Yeah, that's the greatest question, if you can figure that out. So you're not supposed to have employees clock in and out for their 10. You have to provide them or make them available. So the way I've been able to defend these claims is that you make it part of your culture. If you have a team, a staff, that is every day, the supervisors know to go around and say, have you had your 10? Have you had your 10? When are you taking your 10? Did you take your 10? In the morning, in your morning lineup. Okay, everybody, it's going to be a busy day. Try to get your 10s all done by 11 o'clock. If it's part of your culture and it's part of your daily language, you're going to have a better defense for someone saying they never were able to take their 10s, because you really can't have them talking it out. So that's really been my defense. Just make it part of your operations. Okay, final checks. Oh, also on the exempt versus not exempt, there's some minimum salary standards too. So the person has to make at least 2 times minimum wage, but that's not the only standard. There's their duties, the duties test as well. Final checks. This is where other employers get into a lot of problems on how they handle the final check. First of all, it has to be paid on their last day of work, not the next payroll. Right? So I give you notice and Friday is my last day. On Friday, you hand me my check. That check is required to be a live check, not a direct deposit. It can be if I specifically request it to be a direct deposit, but you're on the hook for making it a live check and handing it to them. It needs to not have any extra deductions. Let's say I said to you, hey, will you give me a $2,000 loan because I'm in a crunch and you can just take it out of my next few paychecks. And then the next week I quit and you try to take that $2,000 from me. What the risk is that you're going to make my hourly wage after that deduction below minimum wage. And now you're going to be on the hook for that. So I had an employer do this, $800, cost them $5,000 in a wage and hour. You hand them the check, and you say, we still need to make this arrangement for this payback, and if you don't, I'll take you to small claims. But you cannot deduct it from their final check. Well, you can, it's just risky. Also, if you have a vacation plan, then any accrued vacation time that's in your policy needs to be paid to them at the time that they leave. So, and I haven't even gone into that, but you want to think about whether you have a sick plan and a vacation plan, or whether you have PTO. PTO is a marriage of the two, and so that would have to be paid out. But if you have sick and vacation, vacation has to be paid out, but sick does not. The other thing that happens during employment is somebody comes to you and says, hey, I need a leave of absence. Or I need to be off work for a period of time. And here's the problem is that there are so many protected leaves. This is such a web. Most HR people that I know struggle to try and keep it all aligned because there's so many leaves of absences that tangle over each other. And depending on your employment and size of an employer is what's going to come into play. So this is a nifty chart that Cal Chamber, I'm a huge Cal Chamber fan. If you want to do anything, become a member of the Cal Chamber site and their HR California, because you get all of these forms I'm talking about directly from them. This great chart says, hey, at what size of employees do I need to follow these laws? And there's 3 pages of these charts, so it really just kind of goes through everything. And at what point? So really, I think a big trigger is 5, and then 25, and then 50, right? There's a lot of leave laws and things that trigger at 5 employees. 25, there's a lot of others that come into play, or 26. And then at 50, then you have the federal laws and health benefits, other things that come into play.
I have another question about the 10-minute breaks.
Yeah.
Can they be included in the employee's daily schedule?
Yeah.
So
you can schedule them, absolutely. That's the safest thing to do. Just don't have them clock out. Okay, records retention. There's 7 different laws that pertain to employers or how long you need to keep certain things. I have just kind of always gone with, look, I'm going to keep an employee's file for their length of their employment and then plus 4 years. But it's convoluted. You need to have a records retention policy and a plan. It can become insurmountable at a certain point, especially, I mean, now it's digital, as long as you've got a really good digital plan and a safekeeping and a way to make sure those records are safe. Back in the day with the paper files, I would have drawers and drawers and drawers sorted by years. And
Do you have to disclose that to, when you interview for a job, like I'm going to, retain your information for 5 years?
No. I think there's a new disclosure that's out there that if you're using a database or some sort of system that holds their private information, such as a payroll system, there's some new disclosures about how that system treats their private information, like is it available for sale and those sorts of things. Lastly, we've talked about all this compliance, right? So you've got all these rules and regulations. You got to make sure you're paying them right. You got to make sure you hire them right. You got to make sure you're offering all these leads. There's so much compliance, but at the end of the day, what really matters, the best way to keep somebody away from suing you is the culture that you create in your organization. And this is sometimes we get so focused on the tasks and the have-tos and trying to stay out of this kind of legal realm that the culture suffers. And if you have a great culture, this is a really good way to kind of keep people from feeling like they want to sue you, right? And I truly believe that if the foundations of your company are based in trust and respect, authenticity, transparent processes, that people are less inclined to come after you. They feel like they know what's going on, they trust you, everybody makes mistakes, I make errors, we make errors, payroll makes errors, and they're more trusting to say, yeah, that was a mistake, just fix it, and they're not gonna go and file a claim right away. But if they don't feel trusted, they don't feel that they're respected, then as soon as you make a mistake, oh, they're like, gotcha, I'm on it, especially if they think you have deep pockets, or you have investors that have deep pockets. Then I'm more inclined to come after you. Or I don't like you, so I can take you out of business. And there's people that are savvy to that. I love this, I believe in the sense of belongingness, that if employees feel that they really belong to a team, they belong to the organization, I enjoy coming to work every day, and to be able to create this feeling of belongingness is zero cost. Really, it's all about your treatment, being heard, being respected, inclusivity. All of these things really kind of help create this feeling of belongingness. And that's where I think like the real diamonds live. Like that's a great company to work for, is when I really feel like I belong and I'm accepted and my opinion matters. And when I say something in the meeting, it's heard and everybody is participatory and respected. The other thing, that I could go on and on about is just, performance and how do you manage that performance. And I talked about, slow to hire, quick to fire, but that's only in that initial stage. Once people pass their introductory training period, you definitely want to have an approach to how you give people feedback and that you give them ongoing progressive feedback. There are companies that are moving completely away from performance evaluations. They're moving more into kind of like in the moment, spot on, day-to-day feedback, which I think is far more rich than waiting for a year to hear how I'm doing. I do like annual goals. I like having I want to have an annual goal. Tell me what my goal is for the year so I can work towards that, but give me feedback along the way. Don't wait till the 1 year. And that's when people get blindsided and get upset. Most employees have anxiety around a performance review because most of us have been blindsided, not been told things, and then at the last minute we get hit with something. I'm a strong believer in one-on-ones, recognition, and at some point you just may have to let go of their employment. You just may have to separate. Things just aren't working out. We talked about kind of their final pay already. You want to make sure so in California is an at-will state. We haven't really talked about this, but this at-will language, you want to have it in everything that you do. But the other hand of that is when you're letting somebody go, I highly encourage you to not use the at-will clause to let people go. Because when you do that, you're leaving an open slate for them to fill in the blank as to what's the real reason why you're letting me go. And they can come up with whatever you want. And you could have a very measurable reason why you're letting them go. They've been absent for the, 10 days in the last month. They've been tardy to work for the last 2 weeks. And you've met with them and they're not correcting, right? That could be a reason. What when you say, I'm letting you go at will, but you've had all of this reasoning to do it, you're opening that person up to go and file a claim and say, they're letting me go because I just told them I'm pregnant, right? No, I'm letting you go because of these attendance patterns. Well, then tell them that. Say, I'm letting you go because there's attendance issue. That's why you're letting me go. So I am not a fan of pulling that at-will clause into my separations. It's dangerous.
And how many times do you need to give them notice for a performance issue or tardiness before you decide to terminate them?
I would say large companies that I've worked with, we kind of go with a 3 notice process.
And
If it's egregious, maybe if it's a one-time and only, and maybe if it's so egregious, not even once. It's like, hey, that's just grounds for separation regardless. Like theft or something like that, fighting. But attendance, I would go with a first written, a second written, and a final written, and then let them go. But you don't have to follow that. But if your handbook says you're going to, then you need to. I also like the word separation versus termination. I grew up in the era of the Terminator, and I just can't. It's like always comes into my head. So I usually change all my doc treatments to separation. I also feel like it's a more respect. I don't know. It just feels. I'm not I grew up in an HR career where it started off very formal and very legalistic. And as I grew and evolved, and I worked for companies that grew and evolved, we moved more to a more relational conversation with employees versus a very legalistic. And that's where I like to live, is creating that relationship. So here's some great reference sites for you. If you need information about employees' rights with disability, leave, unemployment, all of those things, the EDD is where to go. I love the Cal Chamber site, HR California. They give you all the forms. It's worth the membership cost to join them if you don't have an HR person. And then the DIR, if you want really like information about injury, wage and hour issues, definitely access the DIR for that. Okay, so I'm going to give you just a quick little 5-minute spiel on some solutions that you have, because as a budding employer, you might be thinking like, this is a lot. And now I don't want to have a business anymore. And I can guarantee you, having employees in California, you definitely, I hear it all the time. The state is just so difficult to be an employer in. It's employee friendly, and it's just really, really tough with the compliance mechanisms.
I have a question. I see a lot of companies establish habits Delaware. The moment you have a footprint in California, you're subject to California, even though you're.
Yeah, it's where the employees are.
So why are they doing that? I mean, they're obviously some.
Maybe for taxes or there might be some other benefits.
Well, I worked for a company almost 10 years ago. A company was based out of Minnesota. We were in California testing. They had issues. They went out of business. They didn't pay me for my last week. And when I tried to follow up, I consulted with a lawyer, and he said, in your contract, it says you're subject to the laws of state of Minnesota, and therefore you can't have any claim. And I thought that was very odd, but maybe things have changed.
I think things have changed, and also it's those contracts. There's most in California, the employer contracts, it's usually only for the top tier executives in the company. When you get to kind of the staff level, employment contracts are dangerous. Like, I don't stay away from them. You can have an offer letter, but a contract's actually going to, I think, hurt you more as an employer than it will provide you safe things. So most employment attorneys will steer you away from employment contracts. But 10 years ago, I don't think that was the case.
Kim, it's 9:55, I think, I don't know if I have a commitment at 10, but, so I just wanted to jump into it to thank you for an awesome training
Thank you so
session.
much.
That was super, yeah, it was fantastic. You covered so
So much.
much.
Like I said, each of those topics could be a good hour conversation.
Yeah, it's so incredibly helpful. And it's very, no one's going to be able to implement all this overnight, but having the awareness of all the regulations, all the rules, at least knowing that it's something you need to dig into is important. So thank you for being such a fantastic resource. Thank you.
Thank you. Thank you. Appreciate it. So let's talk about some options and some solutions for you. So this is from the Bureau of Labor Statistics of small business survival rates. I mean, this is terrifying. And that's what my organization, that's what we do. We team up with small businesses to help them be successful. And you think about, just the impact that over a 10-year span, how many small businesses just don't survive. So here's your administrative options. We've talked about a lot of things. So what do I do, right? Well, you could take this on internally. You could hire people to come in and really help you kind of navigate all of these compliance issues and everything. But that may not be in your budget, and it may not be the wisest move. You can align with a professional employment organization, which is what I represent. That's who I work for. And then you can have some sort of hybrid approach where you maybe bring on some, but you consult with others and you kind of create this mixed bag. When you talk about the professional employment organization, that's a PEO. And basically there's different types. There's what's called an administrative service organization, an HR organization, and a professional employer organization. So an ASO basically comes in and does your payroll services. And then they might do some of your, some HR things for you at an extra cost. And usually you are the employer of record for everything. Okay, so this is like, it could be like a Paychex or an ADP, right? Some of those companies would be like an ASO. An HRO is basically like an HR consultant that would come in and do, they're not going to do your payroll. But they're just going to come and provide you HR guidance and help you with your onboarding and kind of those things. A PEO is all of those things kind of combined. So a PEO, typically, they do your payroll, they have a human resources team, they become the employer of record for federal processes, because what you're doing is you're coming onto their work comp policy as part of a multi-employer group. And then in some states, you take state tax ID, and other states you take on the PEO state tax ID. It depends on the state. And really what the PEO does is, we go in and focus on our clients, so the clients can focus on their work, and we take on those compliance mechanisms of all the different things that need to happen in a small company. So the manager can be focused, and the client business owner can really be focusing on what it is that they're doing. There's currently over 1 million businesses in the United States that have between 10 and 99 employees. The average PEO client is about 22 employees, and we add about 100,000 worksite employees and about 6,000 clients a year. About 15% of all businesses with an employee of this count partner with a PEO. Statistics are showing NAPEO is the National Association of PEOs. 50% are less likely to go out of business. You have less turnover, and they typically grow by 7 to 9% annually when they partner with a PEO. And basically what you're doing is you're partnering with a group of experts. Like in our team, I've been doing human resources for 25 years. We have a risk consultant. He's been in the industry for years. He helps with all the CalOSHA and the risk status, and especially with all the COVID issues and the ETSs that have been coming out. We have a payroll specialist who's doing payroll for 30 years, who knows those ins and outs. And when you process a payroll, we see something like, hey, they just processed a payroll and they just changed this person from hourly to salary. It prompts us to actually, we care about our clients, to pick up the phone and go, let's talk about this. Are you sure it's what you want to do? And make sure you're covered. Whereas another processor will just process that payroll and not even alert them that there could be a problem. So our goal is really to advocate for our small businesses. Our goal in this region, and our model is is that we have a branch with a 50-mile radius for our clients. And so it's hands-on. I'm out at my clients' work sites. I'm sitting with the business owner. I'm helping. I have a client who just opened up a brand new spanking business. And, you know, I'm just every step of the way, just being there with him to make sure he's got all of his pieces covered. And when he got stuck on the ED site, you know, we sat down together and I got it set up. Just that kind of assistance, just like I like to call it, high touch service for our clients. So that's all about me and our business. I do have, for those of you online, thank you for being here today. I don't have pamphlets for you, but I do have some on the table and my business card. And for anybody virtually who'd like to reach out, I'm happy, feel free to email me. I'm happy to assist and tell you more about our organization, or if you have a quick HR question, I'm very happy to help. Are there any more questions, Madison?
No, but I just have a couple quick slides to share from our end of things. Oh. All right. So as Judy said, thank you again, Kim. It was such a wonderful session today. Very, very important topic. Definitely. I think everyone can definitely get some use out of everything that was covered today. Just a couple quick updates on some upcoming events. We have a digital advertising masterclass coming up May 18th. We have Steve Burnside with us once again. This will be his second workshop with us this year in his digital marketing series. And then we also have a coffee and conversation coming up May 19th with some AngelCon investors. So it's a fun opportunity to kind of hear the back end of how everything works for AngelCon and what they're looking for in startups and their experience with it. So we hope you can join us then. But that's about it. Thank you again, Kim, and thank you everyone for joining us. We'll be sending out the recording later today.